Olá, dou boas-vindas a você ao nosso canal Direito sem Formalidades. Já faz algum tempinho, né? Mas a gente estava preparando um conteúdo bem legal para a gente falar com você hoje. Você vai assistir a uma apresentação em inglês no encontro da Law and Society Association, que ocorreu nos Estados Unidos, em Denver, no início do ano de 2024. A gente preparou esse vídeo para que você possa entender e para que tenha uma divulgação sobre a importância, né, dos conhecimentos tradicionais. Essa pesquisa tem o apoio do CNPq, do MCTI, da CAPES e da FAPEMIG. Mas espero que você goste. Não esqueça de curtir esse vídeo se você gostou e ativar o sininho para que você tenha mais notificações sobre os nossos próximos vídeos. E aproveite ao máximo as informações que a gente tem nele, mesmo sendo em inglês. E até a próxima.
I'm going to talk about patent rights and traditional knowledge, the case of mirantã. It's a typical plant from the Amazon region. My name is Marcos. I'm from the law school of the Universidade Federal de Juiz de Fora, Brazil. So this is part of a long-term project on the appropriation of traditional knowledge associated with natural genetic resources. It is interesting to talk about at this specific moment in time because now they have just approved in the World Intellectual Property Organization the new treaty for intellectual property rights, traditional knowledge, and genetic resources. But I've read this new treaty. It was approved of in May 24, just last month. And I'm going to focus that this specific work is based on mirantã. It's Pitacopetalon species from the Amazon basin. It is typical of the Brazilian Amazon region and the French Guiana Amazon region. So this is a native to the tropical forests in Brazil and French Guiana, also known as Muirapuama or Marapuam. And it has been used for a long time before of course, the multinational companies discovered the properties of this specific plant. First of all, it was literature review involving ethnobotanical studies, and these studies, they show us how traditional people use this plant for specific purposes, and that is nerve tonic, depression, anxiety, sexual impotence. Normally, elder people, convalescent people, they are bathed with the barks of the trees, and also they are going to use the infusion of the bark of the trees so that they could in alcohol, in a specific alcohol in Brazil, cachaça, and wine, and they are going to treat the person for all kinds of ailments concerning these specific uses. So it's used by Amazon indigenous peoples, and this is alcoholic tonic for nerve weaknesses, the treatment for physical and mental stress, strokes, and concentration difficulties. These are all traditional uses. I'm not talking here using, I would say, the pharmaceutical language. I'm just using, first of all, the traditional uses of mirantã. It is sold in local markets in Belém, for example, in Brazil, for various medicinal purposes. Well, what was the research methodology of this paper specifically? Our data collection was based on the patent scope database from Whipple, and we used to collect information on patents mentioning mirantã. It's a bit tricky because the patent scope database is not tailored for us to get things that matter sometimes. First of all, we have to read all the abstracts of the patents. We have to read the claims. Lawyers are more aware of this language. They say when you have a patent, for example, that product, that invention should be novel, should have inventiveness, and all of this can be proved by the claims, what kind of claims they are trying to get with the patent. Well, and then, of course, we used the grounded theory approach for analysis because we wanted to cross-reference the traditional uses and the claims and the and the description of the patents. We found, of course, patents utilizing mirantã, but of course I had to look for other names like Murapuama, Marapuã, Mirantã. So it is kind of complicated and tricky. It's kind of a thicket. You have to try to find the words and how they use and what kind of medicine they are trying to produce with those terms. Our search yielded 217 results, but we have to filter this search, and then we found out 9 patents. So the criteria to select those patents is that they should use mirantã as the main ingredient, not as an example, not as something just like a comparison with other medicines. In this specific paper, I tried to analyze some of the patents. It's a work in progress, in fact, because I want to dig deeper these connections between patents and traditional knowledge. So the first patent, there's a composition for relieving physical and mental fatigue. Is it close to the traditional use? Is there any coincidence here? The third one, phytonutraceutical composition for erectile dysfunction. Is it erectile dysfunction kind of sexual impotence? So medicinal plant composition for treating sexual dysfunction. And there are other ones, like for example, those for diet, specific for kind of using just to, there are all sorts of possibilities, a number of uses that kind of reconfigure in a very technical way. And it's interesting because when we're talking about this new treaty, I'm not kind of exhilarated about it or excited about it, because I think that they are going to always, when we're talking about law, we're always talking about a matter of interpretation. And who is going to interpret that international treaty and how this international treaty is going to be interpreted? That's a question. It's an important question, because if they say, oh no, there is a kind of novelty here because they don't use this specific product with this specific chemical. One of the patents I could find when I was doing this research, we use, for example, mirantã with meca, ginseng, all sorts of other kinds of traditional plants used by traditional peoples. So the similarities in the use for mental and physical stress relief. Patents often combine mirantã with other plants just to claim novelty, inventiveness. So, the system is not made to help, even to detect if there is traditional knowledge involved. And according to the new treaty, we're going to give the person the possibility of saying, oh, we are using traditional knowledge. We didn't know that, but now we know. Sorry. So the correspondence between traditional use of mirantã and patent inventions, the indications of appropriation of traditional knowledge is clear, and that's what I wanted to prove.
Se você chegou até aqui, muito obrigado por ter assistido esse vídeo. Espero que você tenha entendido a importância de se protegerem os conhecimentos tradicionais e como que esse processo de apropriação desse conhecimento pode ser ruim para toda a sociedade como um todo e principalmente para os povos originários, principalmente os povos indígenas. E além disso, como que esse processo de patenteamento pode ser uma forma de colonialidade do poder e do saber, de forma que a gente acaba naturalizando o fato de que esses recursos genéticos naturais e a forma como os povos originários se utilizam dele é facilmente apropriado, né, por grandes empresas, por grandes corporações. Se você tiver mais interesse, a gente vai deixar aqui embaixo links, né, para artigos e vídeos que nós fizemos durante esse período aí. E a gente te aguarda aqui no próximo vídeo. Até mais!